Ms. Meeks, how are you?
How are you, Mr. Brown?
Alright, I've already called us to order,
Sorry.
and we'll do the update on the challenges, and we did have a very interesting email from Miss Thomas. I asked that be put on our agenda.
Madam Chair, can I give something to Mr. Cox first?
Sure.
All right, a motion to intervene.
Okay, thank you.
Can we make a copy of this, so this needs?
Copy of
these
the letter?
Emails.
Sure.
Let's see.
Can I borrow one of y'all's
Sure,
real quick?
you can have mine.
That would probably be the easiest way.
I used to hate going to school board meetings and they would talk about all the
Yeah.
stuff I numbered and you never had a clue what they were talking about.
I'm sorry, I should have thought of that.
Yeah,
I'm
you
sorry.
should have went to law
Excuse
school.
me.
Quoting all the civil procedure here and stuff.
You'll never believe where I got it from. Anita Earls had a nice one on the
Oh, really?
web.
Okay, there you go.
I was following in good footsteps.
Hold it.
Is this yours, Mr. Skinner, the sign-in sheet? Is that yours?
Yes.
Okay.
I was told they didn't teach that in law school though.
They don't teach a lot of practical stuff, they don't. They'll teach you about an intervener, but they don't teach you like how to draft or do it, no, they won't. Mm-mm. They don't teach you how to draw a power of attorney or any of that stuff, no. At least not the school I went to.
Thank you.
Okay. And this is. Excuse me, I didn't mean to click on it. I have additional copies for.
Anybody want that?
Yeah. I know David might need one.
Yes, sir.
Okay, why, can we look at this while you look at that? or not?
Absolutely, absolutely, good for you, yeah,
Okay.
don't let me hold you up, yeah. Michelle, I've got a hospital meeting at 10 that got added since this last meeting, so
Okay, so
that stuff's going up there.
That's why I put the challenges on there first.
Yeah.
Thank you.
Thank you. I will say I was kind of surprised by this email, especially that the person thinks they can decide who is challenged, who is subpoenaed. And,
I will say that when I talked to Mr. Scheid, Angela Burke was the only one he could remember the name of. I'm assuming she's the one on the contract. He knew that there's another man and a woman there, and he also mentioned the name Jasmine, but he did not have, and he had no clue what the man's name was.
well, it looks like she's saying that this lady gave her permission to use her address, which is kind of, I don't know how good that is. And then Mike's thing was that we had to have something in writing from her if you wanted her name removed from the role, correct? So I guess it'll be the board's decision if we're gonna remove her from the role. But even if we remove her from the role, what she's done is not right, and I think we still have to deal with that.
Right.
Mr. Cox,
Right.
right?
My thing is, she was looking for a job, right?
As far as I know,
As
yeah.
far as we know.
Yeah.
She
And
had a
you-
job. She had a job at the time. She's been working there since last summer.
Miss Meads, you can't
Sorry.
interrupt the board.
Mhm. Well, we'll get to this. I did a little research myself, so carry on now.
And I'll say this, and I did talk to Don. I didn't give him the facts of the case. I said, if somebody is out of state and they want to remove their registration, how is that done? He said, number one, you can go and register in that state. All 50 states have a box that you can check, do you have a prior registration? Or a letter signed showing the date of birth to verify that is the person. That's what my direction was. Or advice, I should say, not direction.
So, do you think that we should remove her from the role now, or we should wait until the hearing to do that? What
Get
would
the
be
original
your-
at least, let's get the original in the mail,
Yeah,
and then,
cause this was sent by email, right?
Yeah,
It's not
yeah.
signed.
That was scanned and.
It's
emailed.
not
That's right.
signed.
yeah.
Alright, and, this is the new,
That's the new roster, yes ma'am. I
okay,
think you'll see the date on that is, 4/4/13.
okay, and we did ask David to see if he could get us a copy of the new roster to use in case there was any changes on any of those people, we at least have that in here. And what is the question about writing challenge on the registration record?
Well, if I may go back, to the roster, that is the most current copy received that yesterday of the housing roster. Worked with a lady, and her name escapes me, but a young lady, Sabrina something. Anyway, I have a call. Very helpful. She actually came to the office and looked at our old roster and asked for a copy of that so she could use that as a guide to make the new one, I guess. I don't quite know. But anyway, I noticed on there, one name jumped out at me when I got the roster, and I got Kelly to go in there and kind of tweak the
Spreadsheet.
went right out of my head, and make it more legible, because the way she presented it, there was almost like a folded piece of paper. There was, you know, the two sides, the left side and the right side kind of came together and overlapped, and you couldn't really see everything. So Kelly got in there and straightened everything out, took out a whole big blank column that had some personal on there, like an ID number or something like that. Anyway, made it a very nice, more legible. And when you printed the one they sent, every other page would only have 2 or 3 names on it. Kelly fixed it so that we ended up, instead of 40-something pages, we ended up with 20-something pages. Anyway, a name, I wasn't looking through the roster, but a name just hit me while I was looking at it, and I saw Nimi Vital, which is a name I recognized, on the roster. So that got me thinking, well, maybe I should just go through the roster for you guys' benefit and see. I found 6 people who were challenged, who are also on the most current roster as living on campus. So I listed the names on my sheet, and I will give them to you either now or write them down for you, or whatever, however you want me to do that. But there are 6 out of 20-something pages.
May I make one? Nimi Vital is being challenged for citizenship.
Well, he has 2 challenges in there. The second one is the same as all the rest of them that remain registered.
And then we do know that there is one student who was, and again, these challenges were based on the November 2nd election.
So I didn't know if that was important, unimportant. I just thought it was interesting. So I went ahead and read those
It's something that
names.
could be entered into evidence, right?
Yeah, and Mr. Vitalis, right, and I've actually confirmed that now, the American Samoa is not entitled to either. Not the evidence that Pete presented wasn't good enough, but that was good evidence, it just, I wanted something outside of somebody's
don't have a
article.
problem with that.
Yeah,
So that was the deal with that. The challenge, the statute reads that every registration record, the word challenge will be penciled in on that registration record. Well, we got to thinking about it, and we don't receive hard copies of DMV records when they're registered there. So I called or sent an email to Don, and Don said that they're in the process of creating a new program within Seams where you can, I guess, specifically mark a box or something in VoterView. Right now, he said that he's telling people to write it on the comment section in VoterView, as opposed to fishing out, like in our case, 60 registration cards out of the records. So we went and did that. Kelly and I split it in half and did it. Didn't take us any time. Finding 60 registration cards could easily have taken a day or 2. So that was nice, and that came from Don. He said they are in the process right this minute of creating some, I don't know if he said he wasn't real specific, but creating something online, because I guess as technology is improving, you know, some of the things like that are no longer necessary. So anyway, he said they're in the process this very minute of
So
creating
you
something.
have pulled all 60 though and written,
No,
what
we
you
did
have-
not. Don said we did not have to do that. He said we could write challenged in the comments section
oh,
on voter view.
on their voter view?
Yes, ma'am.
Okay.
Which
But-
is their record online.
So,
It's just not there.
on our county record, for each of those 60 people right now, it does say challenge.
Yes, ma'am, on every
That's
single
what
one
I'm
of them.
looking for.
Right. We
That's
just didn't,
right.
you know, the statute says pencil it in on the card, and the statute is probably old and, you know, so I called Don and said, is that what we need to do? Which we would have done, or tried to do.
Right,
This made life much easier for us.
we just wanna make sure that somewhere in the official record.
Right, it
They
is
have
on, it
challenged
is on
on
the
that.
record. Yes, ma'am.
Okay.
So,
Hearing location update.
that's just a quick update. The auditorium's been reserved for the hearings. Sheriff's officer's been contacted. I actually did that yesterday. He hasn't called me back yet about security. All the notices have been sent out. As of yesterday afternoon, yesterday's mail, we had not received any back, but we just mailed them Wednesday, so
Right.
we wouldn't have them back yet. They may come back today. And that's pretty much all I have on that.
And may I ask you that if you do get some back, will you email those names to Mr. Gilbert?
Yes, ma'am. I certainly will. As they come in, I will.
That
Last
way
time
he
what
doesn't
happened.
have to call.
Right. Last time what happened was they all came back in one day, and then we got two more scattered out. One really recently, which was kind
And
of
he's
bizarre.
been emailing me too.
Yeah, and I've been
Okay.
sending them
Okay.
to them already. They made that request and everything.
In the law book, I believe it says we have to record that the same way we do our regular meetings.
I think so.
Now, we are recording our regular meetings with Skinner's tape thing. Ms. Mead, you are gonna record that with a video camera.
We're planning to have a court reporter.
Okay, great, okay. but-
With the stipulation, if anyone needs a transcript, it's fault from us.
Right.
It's our personal.
Right, right.
Okay.
That makes sense. Thank you. That takes care of that problem, because I was trying to get a video camera from church, and it only holds like 4 or 5 hours. It's a real, that professional
That was a nice one.
Yeah,
Yeah.
but like the
November.
cards to hold for 32 gigabytes are like a couple $100. So I actually brought the picture
Well,
of the card today.
I will have my camera there, so.
Okay, I
but
brought the
we are
card
gonna have a
today
court
in case
reporter.
we had to do that, just in case, so we could get Colin to order it for us. But-
We understand the constraints on the county budget.
All right, thank
Okay.
you. I appreciate that. All right, subpoena for Don Wright is the
But,
next. Yeah.
if I could,
Yeah.
Mike, do you mind if you share that motion to intervene before we get into
Betsy
Don Wright?
has filed a motion to intervene. And it is similar to, as she said, Ms. Earls went filed, I think, in the Kirk Rivers matter. You know, frankly, this is new. You know, if you would assign those challenges, then you're in just the same as Mr. Gilbert. And if there's some way to get you to maybe swear to those, and I'm just throwing out an idea right now. thinking
Well, I
out
mean,
loud.
according to the statutes, it's allowed, and they're attached. Because this is an administrative hearing, and the State Board of Election, anything that the State Board of Elections does other than,
Sorry.
Article 8A, which is have administrative complaints, is covered. And,
This is administrative hearings.
yes, this is, because it's a quasi judicial board.
150B is the administrative.
It comes under quasi judicial,
I'll take it under advisement and consult, I mean, if there's, that's, I mean, go ahead and
and I
point
mean-
out what you want to. that's
and
fine.
I will, other administrative hearings, the State Board of Elections and the administration, this is 150B 38-6. Basically, any, Board of Elections from 163 except I have a complaint, and under F, any person may petition to become a party by filing with the agency or hearing officer a motion to intervene by GS, as provided in GS 1A-1 Rule 24.
Sure, go right ahead.
It says the State Board of Elections in any under, are we under 22A?
No, that's the exemption.
The State Board of Elections, all right, I don't wanna spend a whole lot of time debating on this this morning, but
Okay.
let's talk a little bit anyway.
And basically-
150B, the State Board of Elections and the administration of any investigation or audit under provisions of 22A. And you said that's not what we're dealing with this morning, right? He's gotta find Article 22A.
Hold on a second. No, that's the exemption. That's the only time that they can't, the State Board of Elections cannot use this, which is have a complaint.
Help me out, 'cause
All
I'm
right,
reading this for the first time.
150B, 150B1, and I don't think it's gonna be in that book.
It's not in this book.
150B1, it should be on the back of my thing.
It is, I'm looking.
Okay, all right. Full exemptions. This chapter applies to every agency except State Board of Elections in administering the HAVA administrative complaint of 8A of 163.
Are you reading A6?
Uh-huh. C6, excuse me.
Okay.
150B-1. Did I not have it highlighted there?
One-
sorry.
I'm-
There's something in blue. Is that
Let me see what you're looking at.
Right here.
We're looking at two different things, yeah.
Okay. Policy and scope of Administrative Procedure Act. And the only thing the State Board of Elections is exempted from is, in using this, is Article 8A of Chapter 163, which has to do with HAVA administrative complaints.
Still not on the same page as you.
Let's see, did I not? One second.
The only 150B I've got is
Oh, okay,
38.
well, here, maybe,
Do you wanna make a
Let me
copy
give you-
of this?
let me give you this one.
You got another copy? You want me to make one for you?
Okay. And this is on administrative procedure.
I
Which
don't
was,
think, I don't, personally, I don't think you need, I don't think 150B applies off the cuff, but I don't think you've got the rules of civil procedure 24. I think it's what you need to rely on,
Okay.
but let's hear it, okay. So this is,
and that's the exemption. The only exemption the state board has.
but it's not the local board.
It includes everything under 163. Local boards are considered quasi-judicial boards.
Understand
And that's
that.
what this is applying to. And basically, this is from zoning, applies to zoning boards too, local zoning boards.
Not 150B. Not 150B. I wanna write this down, 150B.
Okay, check,
Yeah.
I've
Make
been
a
led to
copy of
this.
it, can't we?
Yeah,
Can
150B.
you
Sure.
make 4
Absolutely.
copies of that so we can all see what we're
I
talking
think you're
about?
fine under 24, Betsy, to be honest with you. I mean, that's the interface
Okay,
of civil.
that's fine.
I don't think APA's got anything to do with,
Okay, so
what we're doing.
under
yeah,
that, are you,
yeah.
do you feel comfortable
Well.
with my motion
If
to
I can tie
intercede?
you into swearing is my guess. If, and this is I wanna do some homework on
Now,
it.
Pete
but
Gilbert didn't have to swear. He only had to have a
Sworn to
signature
subscribe.
notarized.
Wasn't it sworn to subscribe? Whatever it was on the, where's the challenge form? Does anybody have one close by?
I have my book back here.
No, I didn't.
I'll be glad to fill out the appropriate sheets for each one, if that's,
It might just be an affidavit or
Okay,
something, or
that's right.
something along those lines.
I
the very
do
bottom.
solemnly swear or affirm. That's what it says. at the
Okay.
bottom.
That would be my gut feeling, something along these lines, but I need to run this by somebody, just to make sure. Okay,
and the reason this is being brought up is, as
Thank
we
you.
know before and in past hearings, we limited who could speak at the hearings.
sure, because it puts me in a bad
I,
spot.
and,
as
and
far
I
as you-
understand that.
Mhm.
Okay, I do understand that, but my understanding is with these quasi judicial boards, because they're not lawyers, you're the only lawyer here. Lawyers do not have to be present at these hearings during these hearings. Anyone who has a vested interest in what's going on and is a registered voter, anyone could ask to intervene on this case. In fact, if this were to go to Superior Court, according to the law, anybody in the county who is a registered voter could appeal this case.
Know what it says? Okay.
So, and you know, basically, I've also been providing information, and I've got on there the reason the preliminary hearings were done in 2 hours instead of 2 days as y'all had allotted, is because of my work on this. And it's in my best interest to see that this goes in a very smooth fashion and stay on point.
And you did a good job of preparing
And that's exactly what we intend to do in 2 weeks. And if you feel comfortable with me, I don't know that if I sign those forms, do we start the clock rolling again?
A decision, that's a concern, too.
What page are you on?
I'm actually on 160, just reading the part, the very bottom. about the appeal.
Okay.
A decision by a county board on any challenge made under this section shall be appealed to Superior Court, in which the office of the board are located within 10 days. Only those persons against whom a challenge is sustained, or the persons who have made a challenge who is overruled, shall have standing to. So I don't think that's everybody. Is there another section?
I was just going by quasi judicial boards.
Oh, nah, this one's more trumpet. But anyway, I mean, we'll look into it and find out if there's a way to get you in
And basically,
There is,
I'm concerned about Pete's health. And again, it's just so that we can make this smooth.
understand. How come you didn't file
He wanted to.
them? Okay. Yeah.
Okay, so basically, all we're trying to do is make you you're just trying to make
Right.
yourself a part of the proceedings.
Just so that I can answer questions and bring up issues.
Right.
For instance, the subpoena, and by law, yes, we have to pay.
Right.
And we are planning to, by the way, he's being called as
Hostile
not hostile, an expert witness.
expert.
Based on his, and actually we're going to be using his slideshow, Resident Statute and Case Law by Don Wright. The other reason we're doing that, and I thought I brought that this morning, is I'm going to note that in September of 2008, during the hearing we had after the appeal of the Rivers case, I actually had pulled printed the paper right off the NAACP website. It's still there. This board subpoenaed 24 witnesses, including city manager, parks and rec head, planning
I
inspectors.
think they were all relevant.
Very few of them were actually called to the stand that day. The other thing
I'll
is,
cut to the chase on this one.
in the same thing, it indicated that Mr. Gilbert had challenged Elizabeth City State students before and that he had an agenda. I think it's very relevant that we have an expert witness who gives us the parameters of students who register and vote on campus.
I'll stick by my recommendation and not subpoena Don Wright. No offense if you do. And my recommendation is just get on the phone, call him.
And then you
if
have
he
to do
has-
that in closed hearing. We want him to take an oath and be on the record. That's reasonable.
I suggest call him now. If he is aware of anybody in this case or any facts, then all right, let's talk about it. If he's just being called as a general, thank you, Kelly, witness or a expert witness, you don't need him. I'm the attorney. I mean, I'm not trying to sound cocky or egotistical or anything, but I'm the
And I
attorney.
understand that, Mike, but I will in these previous hearings, this board had to go into closed hearings, and you had to call and and ask questions on our behalf. I think Mr. Gilbert should be able to ask questions on the behalf. I think if anyone who shows up should be able to ask questions and not rely on what comes through this board from
That's
Mr.
my
Rock.
recommendation.
All right, what exactly are you looking for him? Because we have arranged to have him on a conference call today to see if there's a relevance. I don't have a problem calling, but if it's not, then
I think he's the most totally relevant person to be called, or any attorney for. I mean, if you want to call Susan Nichols or Bob Joyce, I don't care. Except he wrote this. This
I rely
comes from
on
him.
books all the time. I don't
I
call people,
I
you know?
understand that, Mike, and this is not a political agenda. The fact is this board has never told the truth about
Our board?
No, they've never been told the actual facts about students registering and voting on campus. We're going to submit evidence that the board has a different view when they're talking to different people, and we need the state board of attorney to answer several questions. He is the most relevant person in this case.
Kelly, man,
We're willing to pay two
wanna
nights
get
of
the,
2 nights of a
State
motel
boards.
room.
phone number, please.
Probably got it on the bulletin board.
probably on the bulletin board.
He will only be asked questions relevant to this. And if he should leave office before 2 weeks, we would ask the next attorney to come up as an official from the state board.
Today's the second day, isn't it, after you, it wasn't yesterday, it was the day before. When I was in high school and playing football, the day after you worked out for the first time in January, you were sore, but the second day, it was the worst. That was worse than the first day.
That second day.
Yep, and the best, and when you're lifting weights, the best thing you can do is lift again, cause it works so well. But it feels like, it feels like you can't lift 10 pounds, you know, it's just, it's a horrible feeling. Maybe you should go lift weights today.
I've got the general number, Kelly's looking for Don's specific
Can
number.
I bring up one thing, 150B-39, depositions, discovery subpoenas. In preparation for or in the conduct of a contested case, subpoenas may be issued and served in accordance. Upon a motion, the agency which issued may quash a subpoena if, upon a hearing, the agency finds that the evidence, the production of which is required, does not relate to a matter in issue.
I don't think 150B applies though. If I'm wrong, I'll tell you, but I'll be honest with you.
Well, then that's where I'm getting where we have, that's where
you're.
you're getting where we have to pay for the witnesses.
It's on the back of the subpoena.
Okay, it's
That's
also,
a civil
it's
procedure,
all,
which I'm giving you credit for.
okay, it's
on
also in
24.
this. But this is directly related to these issues. He wrote it, okay? It's got his name on it. It will be presented that
I
day.
use Gray Wilson's, I use West, but I don't subpoena West to a hearing, you know? I mean,
Does not relate to a matter in issue. The subpoena does not describe with sufficient particularity the evidence, the production of which is required. This is the only thing he's gonna be questioned on. Probably just in one case.
I actually go to the law books. I mean, that's great in a guide, but if I go to court and say this, that's not as good as what's quoted in the law and the case notes.
Let me ask you something, that says that, what were you saying, quash?
You may decide not to do it.
We could quash this, could the state board of election quash?
Absolutely, and probably what's gonna happen.
If we did a subpoena
If we get
against
him on
him?
the phone and he says, and you've mentioned one or two people, if he says, I don't know who you're talking about, I don't have any idea, he's gonna go to his chairman and say, I've gotten subpoenaed to go to court in Elizabeth City, I don't wanna go. And he's either gonna go to Wake County or Pasquotank County and move to quash that subpoena.
And that's fine. I don't have a problem if he does that. That's within his scheme.
You're gonna have me going to Wake County, wasting my time on a trip that I know is fruitless if you subpoena, if he has no, now if he gets on there and he goes, I know Mr. Vitale, or I know whoever.
An
you
expert
know.
witness doesn't have to know the person.
The other day it was, he had something to do with one of them though.
No, he doesn't have anything to do with them. He has to do with the law that we're challenging this person on.
Expert witnesses though, I mean, you don't need them. Can we call them? I mean, I gotta go to the hospital.
No, the
I'm not
other
gonna sit
day
here
you
and debate
said
this all day
it
long.
was for one person.
It is for one challenge. He's being called as an expert witness for one challenge and one challenge only. And this is to do with the student who lives on
David.
campus.
I just unplugged it, I'll plug it back in.
Okay.
Is
Is it on the
Wait,
side?
did you
Okay.
find a number from him?
Yes.
Yeah.
And also,
Yeah.
it also says, however, state officials or employees who are subpoenaed. So state employees and officials can be
Are
subpoenaed.
you reading the APA again?
Yeah, I guess it doesn't, other administrative hearings.
Does it come on?
Yeah. It takes a second sometimes, actually, we just went through this.
I would think that
Yesterday.
any employee, when there's a challenge who can help the local board, you know, they don't just serve the boards, they serve the voters of North Carolina. And the voters of North Carolina don't get to go to these educational facilities and find out things. Or question. And in fact, when we go, they're not, I actually asked Veronica DeGraffenit about something, and what she did in August was said, we don't mess with the college students. And she wouldn't answer my question. She wouldn't even let me finish the question when I mentioned college student. That's not right.
They're trying to appeal. That hadn't been messed with. It was on right before the meeting started.
Okay.
Maybe I'm in the wrong one. I actually unplugged it because you can't completely mute it. So.
I think I saw something flash. Let me see.
Maybe we just
Yeah,
take
there
it
it
off,
is.
there it goes, okay.
My recommendation, I would hope that the board would honor this request, and if Mr. Wright feels like he needs to do otherwise, he can do it.
I'm sorry to step right in front
That's
of you.
okay.
Trying to get this-
I've got a nice picture of you, let me turn it a little bit.
And again, this is recorded, so you can replay it and watch it, me say this every time. I've never heard of the administrative APA applying. If it
And it
does,
may
I'll tell you
not.
I'm wrong, but
And
I'm just
listen,
telling you,
it may not.
springing this on me this morning. And I gave you credit for Rule 24, I said I'd look into it, you know, but I just don't see
What is Rule 24 while we're getting?
intervention. Betsy has
That's
filed a
Rule
motion to
24 on the
intervene. Yes.
Intervention.
Yes. As a matter of fact,
I made 4 copies. for
you
each.
did or you will.
I did.
And I would like
Okay.
to remind this board that this board asked me to prepare information for that hearing to make it easier for them. So they have included me already.
Well, I'm not gonna go there.
Thank you.
I will repeat I will say to the full board, I've told some of y'all, and I've mentioned this, I've alluded this to Betsy earlier. There are ethical rules that if this is a quasi judicial hearing and somebody is not an attorney, that I am supposed to advise the board, and it puts me in a bad ethical spot. And I've advised Betsy as well about that. I'm just stating that.
Because we had that problem with Miss Kerber one time.
And I think the point of these,
It's been
the
clarified
point,
since.
the
yeah.
point of the quasi judicial is that you're not attorneys. And the persons who are, in fact, even in the challenge, it says the challenger can ask a person to represent them. It
That's gotta
doesn't,
be an attorney.
it doesn't say that in the law. It says a person.
I wouldn't want to challenge that one, but anyway, you may and you feel free to, but.
But
I understand that.
because election law comes down, the board does not go after election fraud. The board cannot do a challenge because they're the judges. Election law comes down to the voters recognizing a problem and doing something to get it corrected. Right? They may be right or wrong. It just can't be frivolous. I think through your preliminary hearing, you've shown that these are not frivolous cases.
And that's true, there's no question about that.
Basically, everything in election law is based on the registered voter taking care of policing registrations and voting.
Don, good morning, Mike Cox and Pastor Tank, how you doing? Don, I'm in the middle of a meeting, do you mind if I put you on speakerphone, please? Okay, 1 second.
Let him know.
Okay, Don, can you hear me okay?
I can hear you, Mike.
Okay, great. I want to tell you, we've got our board in here, our director, assistant director, my assistant, and Betsy Meads, okay?
And it's being recorded.
And it's being recorded, yes.
Okay.
Don, the issue has come up about subpoenaing you for these voter challenges here in Pasquotank. It has been my recommendation to not subpoena you, not sounding egotistical, but I'm the attorney and I'm interpreting the law here and advising the board. I'm just trying to see, and Betsy she says that you can be helpful to 1 or maybe 2 of these, and I don't know if she wants to divulge the names. You know, I don't mind subpoenaing people if I think they're relevant. I just don't think that you're relevant to these cases, and no offense to you on that one.
Well, Mike, as you know, the general law subpoenas as to factual witnesses to situations that are before the body hearing the case. Unless my memory can be refreshed, I have no recall of any information as to these 60 persons. In fact, I haven't seen the 60 challenges, and you do not subpoena people for opinions on the law or legal opinions. You are entirely correct. What the law counsel. As you know, as everybody knows, I'm general counsel of the North Carolina State Board of Elections and do not have an attorney-client relationship with any county board, but as a matter of policy, we help county boards and the public in regards to locating law, informational law, actions of the State Board of Elections as to election matters. So I would be more than happy to hear any information that would lead me to believe or refresh my memory that I have some knowledge as to the facts surrounding any of these challenges.
Don, this is Michelle. Miss Meads has said she would like to call you as an expert witness because of your residency statute and case law PowerPoint that you have provided to the boards of elections.
Huh? There's no such thing as expert witness in law.
We're not asking him here as a
With all due
lawyer, we're asking him
respect,
here as an expert witness.
You're the trier of the fact. In American jurisprudence over the past 200 years, I am unaware of any court that has, or any body hearing a case that has surrendered its authority to determine what the law is or is not to a legal expert on the law. There's no such thing in American jurisprudence. You're the trier of fact, and I'm talking about the Pasquotank County Board of Elections, you're the trier of fact, and you will determine what the law is to apply in this case, and if you are incorrect, it goes on appeal. But there's no such thing as an expert in law to testify. This is unheard of.
May I let Miss Meads explain to you what she's looking for from you?
Okay?
Mr. Wright, we're gonna be,
Good morning.
good morning, how are you? I want you to understand, you're not being brought in as a hostile witness. You're being brought in because this board in 2008 was vilified on the NAACP website, and the challenger was vilified for challenging students who reside in dorms on the Elizabeth City State campus. Now, we have one student in this challenge, and these challenges, that is a resident in the dorms. But in the preliminary hearing, it was shown that she may show domicile elsewhere. Now, your residency statute and case law is inherent to this hearing, and we would like verification just to question you. You will be questioned specifically on the record, so that the challengers, the challengees. Elizabeth City State has a big stake in this too, and they're taking this very seriously, and so they should. But the voters in Pasquotank, this board, who have been through enough challenges, deserve to have concrete answers to questions that are sometimes not answered correctly.
Ms. Meads, with all due respect, I really don't understand what you're saying.
Do you have any problems answering any questions that may be posed to you on this residency statute and case law?
I can't. I'm the general counsel for the North
You wrote
Carolina
it.
Board of Elections.
But you wrote it.
I'm sorry?
You wrote this.
Right, and the trier of the fact, Ms. Meads, determines the validity of that information. That is, in American jurisprudence, the way it's been for a couple centuries, is the trier of the fact, i.e. the court or the Pasquotank County Board of Elections, is up to them as to what weight of evidence or what credibility they give to written evidence or to a thesis on law in the matter. You don't call, and you're getting an area which is completely unheard of in American jurisprudence. You don't call the author of a legal treatise, the court does, and questions him. The court reads it and may or may not consider it. That's like, even you've seen United States Supreme Court arguments, and you may not, and you may not see appellate arguments. You have information submitted, but it's up to the court whether they consider it or not. And in this case, the court is the Pasquotank County Board of Elections.
That's okay. Let me clarify something then. So you're saying as a lawyer you can't do this, is that correct?
I'm saying no lawyer.
Okay.
Myself
Then
or
I would like,
comes in and offers
We
expert
can-
testimony as to what law
okay.
should be followed when a entity, especially this entity, is represented by counsel, and let me go on the record. And listen to me carefully here, everybody. I remember long, Ms. Meeks, before you became active in challenges, that Mike Cox would call me up, and I would even talk to him on my cell phone while driving as to challenge matters. And Mike Cox is the most experienced and knowledgeable county attorney in the state of North Carolina as to challenge matters as a result of the extensive challenges that have occurred in Pasquotank County. And in fact, he has superior knowledge than I do in regards to the actual hearings and the practical aspects of holding these challenge hearings, because he's done more challenge hearings than any other attorney in the state of North Carolina.
Mr. Wright, I wholeheartedly agree with you.
For the Pasquotank County Board, and they cannot bring in the attorney for the State Board of Elections nor any other attorney as they, quote, expert witness on the law. That is for the Pasquotank County Board, and if they make an error in the law, the person that thinks they made an error can appeal to the higher level. Now, Ms. Meeks, again, with all due respect, have you consulted an attorney in regards to your allegations that they could be an expert witness in law?
I would like to think that anyone who wrote something would, if they wrote it, they would be an expert at it. But I would like to, actually, Mr. Wright, I think since an attorney cannot be, obviously it's just attorneys that can't be subpoenaed as expert witnesses. We'd like to modify our subpoena.
You have an expert witness on matters where the court needs expertise. And the courts do not need expertise in the law because they're the sole judge and trier and judge of the law and which law should be applied. Expert witnesses are tendered on factual matters, and I've never heard of an expert witness in a challenge hearing. Expert witnesses are usually in criminal matters as to cause of death, civil matters as to cause of accident, civil matters, medical expert witnesses as to the effect of an injury on someone, but you never have expert witnesses on telling the judge or the court what law should apply. And again, in this context, look at Mike Cox. You got the best county attorney there in regards to the matter. Now, Ms. Meeks, if you can refresh my memory as to any facts that I may know of pertaining to your challenges, and if I have knowledge of those facts, then I can be a witness as to those facts if I have any knowledge of them. And Ms. Meeks, refresh my memory. Do you think I know anything about these challenges factually?
I think you could give us light on the 4 prongs of residency that are addressed in your residency
That's
statute.
a legal issue, man. I'm talking about facts.
Okay, all right, then let's back. Can we back? Mr. Wright, I think I can end this quickly.
I've seen the challenges.
Mr. Wright, I think I can end this quickly, okay? We agree. First, we think that Mr. Wright could provide something, and I'm appalled that any paid staff member of the State Board of Elections thinks that our local attorney has got more knowledge about residency issues than they do. But regardless, if there's an attorney issue because of him being attorney, then we would like to resubmit that we subpoena Gary Bartlett, who's not an attorney.
For what?
We will be showing a video of Gary Bartlett addressing the legislature on this issue, and we would like to have that established in this challenge hearing.
Listen to, and again, respectfully, listen to me. This is a challenge hearing which is determined upon the facts, number one, the facts, which people have to have personal knowledge of. Number two, the law, in which the Pasquotank County Board will determine what the law is, and upon reliance from their counsel, Mr. Cox, which again I will state is extremely competent, I would say the most experienced county attorney. you can have, no one else can provide in this agency that I know of any testimony as to the facts of this matter. I cannot speak for Gary Bartlett, but I can tell you that based upon my communication, I would be 1,000% surprised if he had factual information as to any of these challenges. As to Mr. Bartlett, he can't offer testimony on the law. The law speaks for itself, Ms. Meeks, and that's a very important concept in American jurisprudence, is that's why we have laws printed. So the law that you have there in Pasco-Tyke County, GS 16385, is the same laws in the hands of someone in Mecklenburg County. And it will be the same law considered by all county boards. You don't tender opinions as to law, as to the merits, as to what it may or may not mean. That is for the trier of the fact, which is the Pasco-Tyke County Board of Elections, and they may or may not choose to listen to Mr. Cox. And I have no problems with that.
May I
That is
interject
their
here?
call.
Just this,
But
this
you
is to
don't
the
bring
board.
outside folks in and say, this is the attorney you should listen to. I mean, you knew that because you don't have an attorney with you now. If you
Excuse
feel
me?
that an outside attorney can give some guidance to the Pasco-Tyke County Board, you would have that attorney by your side right now and say, hey, listen to this attorney.
Mr. Wright, I want you to understand that North Carolina law provides that the voters end up being the election police. And nowhere in that 163 does it say that a registered voter has to get an attorney to make these challenges, because it would be cost prohibitive. Now, I would like to address, Mr. Wright, just give me a moment, please. Mr. Wright, give me a moment, please.
Just a minute, let her speak,
The
please.
voters are not the police per se, is that any citizens can file a challenge. but
Any
it is
registered voter.
Is the Board of Elections. So,
The Board of Elections are the judge.
Mr. Cox would not be giving the Pasco-Tyke County Board of Elections correct legal advice, then I would suggest that you have an attorney of your choice with you, and then that attorney can object during the challenge proceeding, saying that the legal position taken by the Pasco-Tyke County Board is contrary to law, and make that argument.
Mr. Wright, this is Michelle. I guess the question is about this,
Sorry.
the PowerPoint that you've done, and it's on those 4 prongs. But in reality, it's up to this board to look at those 4 prongs and determine if those students meet the 4 prongs along with advice from our attorney.
That is correct, and in fact, there's a case from the North Carolina Court of Appeals that overturned a ruling by the Edgecombe County Board of Elections, where basically they turned to an attorney and said, you tell us what you think, and the Court of Appeals said it is the job of the county board to digest both the facts and to apply the law as they see it, to make a determination, not just to turn it over to someone, an expert in law, and say, what do you think? I think Mr. Cox can, I believe, Edgecombe County versus Knight, I think, that was the Court of Appeals case, came out about 5 or 6 years ago. But, Madam Chairperson, you and your fellow board members, you are the trier of fact. You determine what laws you apply in this, and you may or may not consult your capable attorney, Mr. Michael Cox, there. Ms. Meese is entirely within her rights to assert her personal opinions as to the facts and the law, and to also retain an attorney of her choice if she feels that would help her case or the case of the challenger. But there is no role for any attorney, including myself, to appear as expert witness on the law before any legal board or court. Like I said, that's unheard of. The judge, and in this case the board, is the absolute determiner of what the law is
Madam
and how
Chair.
it should be applied.
Can I add something?
And that's the
Oh,
way it's
Mr. Wright.
always been in this country.
let me say something. One thing I think that's caused a lot of frustration here is our county spent tens of thousands of dollars on all of these challenges. We had one overturned by the Superior Court because of the 4 prongs, and then the person actually never even lived in the place that they asserted was their residence. And it's, I guess it's getting kind of frustrating to the people in Pasquotank County, but I assure you that this board has tried to follow the law in every case that has been presented to it, and I believe Mr. Cox has he's gotten us advice from the Institute of Government, he's gotten advice from your office, but when it all comes down, it's been the board that's made the decision based on what we've gotten from all these other people. We have never turned things over to Mr. Cox, we have asked his opinion, but by law, when it comes down, it's the 3 of us that are going to decide this. And Ms. Meads would like to ask you something.
Mr. Wright, I've got minutes of our 2008 hearings, challenge hearings. During those hearings, and I was on the board at the time, we went into closed session for attorney-client privilege. At that time, at some point, our attorney was actually asked to call you for clarification on matters. So I'm assuming you're saying this board doesn't need to go in closed meetings during these challenge hearings to ask anything because they're the experts. Is that what you're saying?
No, I said they can always go to closed session to consult with counsel, ma'am.
Right, but our counsel would call you for counsel. So it's only fair. In fact, I will tell you at one time in the last hearing, and it's on the record, in the last hearing in September of 2008 on the Kirk Rivers Challenge, resulting from the appeal, chairman requested to go into closed session. We did not do that. I made the recommendation that that we go in recess. She left the room with Mike Cox. They called you for advisement on the issues. Now, I think it's only fair that the registered voters in Pasquotank have the same opportunity, that we don't go through people to find out what the answers to questions. It should be on the record.
Ms. Mead, you're a citizen and registered voter in Pasquotank County. You do realize that I'm the general counsel of the State Board of Elections. I don't represent you. I represent the State Board of Elections.
And you also represent the Pasquotank County Board of Elections and the due diligence of their duties.
Citizens and the public where the law is and where to find the law, and we will produce documents which people can read and take what use they want to, such as the document I prepared. But, ma'am, no, you have no special standing before this board or in the General Court of Justice to have the same access and same rights as the trier of fact. And Ms. Meads, and again, with all due respect, have you personally consulted an attorney on these theories that you have presented this morning and gotten advice from an attorney?
No.
Okay. Perhaps you should.
I personally, as a registered voter in Pasquotank County, I don't see it's that I should have to spend a lot of money to correct inadequacies in how our law is being administered.
Don?
And the State Board of Elections is the one who administers the law to these county boards.
Don, Mike here. If you don't mind, I'm going to request we cut this off at this point. My purpose of calling this was to ask Mr. Wright if he's got any knowledge of these cases. I'm sticking with my recommendation. If there's any follow-ups, otherwise, I've got another meeting at 10 I got to get to, and we're not through with business right here. So.
Okay. Well, Mr. County Attorney, I understand that because you represent the board, so I understand this is at end.
Right. Well, I appreciate it, Don. Thank you. I just wanted to see if you had any knowledge of these, and I appreciate your time.
All right. Have a good day.
Thank you, sir. Bye-bye. Appreciate it. You too.
And I'm going to remind this board that in September 2008, we subpoenaed 24 people who had no, for the same reason that Mike St. L. They had no intimate details of why they were being subpoenaed to the case.
I've made my case. Not my case. I made my recommendation. That's all. I'll
I
say.
think the difference being though, I think he has explained that lawyers don't give testimony on something they've written. Other lawyers other
Thank
lawyers,
you.
they quote those cases. Like all those little things at the bottom of our
Yes.
book, like Babs versus whatever it is,
Yes.
that it's up to us to look at any information that we have and make our decision from that, and then if it's appealed, it's appealed.
And if something happens with one of these, you find that they were proper to remain registered there, and if Mr. Gilbert and if it's Ms. Meads as well appeal, then they can cite that in their appeal. I mean, that, you know, you wouldn't subpoena this person, we think they were relevant. I'm gonna tell you, I don't think it'll fly in 100 years, but that's the petitioner's right to ask. I mean, this would be over in 1 minute Superior Court. I mean, trust me, this is.
And I don't have a
Gone.
problem with that, Mike.
Gone.
Okay, I just think it's time that for the taxpayer funded board that administers this law that the legislature draws up, at least answer the questions and how they administer it, because it's not administered fairly in education to the boards and to the public. Now, if he seems to have a problem only because he's an attorney, so we'll be glad to withdraw his name and have Gary Bartlett subpoenaed, because he will be on video in this hearing.